the third discussion or the part 3 of the negotiable instruments law. We now go to section 5 of the NIL. Kung mapapansin ninyo guys, pa-jump ako ng discussion ko para makorelate ko yung one section to another section. Okay, we start with additional provisions. Okay, an instrument is still negotiable even if the following are present. Okay, number 1, authorizes the sale of collateral securities in case the instrument be not paid at maturity. 2, authorizes a confession of judgment if the instrument be not paid at maturity. Number 3, waives the benefit of any law intended for the advantage or protection of the obligor. 4, gives the holder an election to require something to be done in lieu of payment of money. Remember yung ika-4, okay? The option or the person who has the right, okay, to require something to be done in lieu of payment of money is the holder. It's the holder of the negotiable instrument. Okay, sige, magbigay tayo ng example sa section na to. With or in connection with the previous discussion na dun sa tanong ko kung can a bill of exchange or promissory note qualify as a negotiable instrument. Yung na-discuss ko dun sa part 2. Please go over part 2 if you cannot remember yung topic na i-discuss ko. Okay, let's say for the example, in the case of Philippine National Bank versus Manila Oil Refining and Byproducts Company, 43 Phil 444. Okay, this is the problem. The manager and the treasurer of MORB company executed and delivered to PNB a promissory note whereby the company promises to pay to the order of the PNB the amount of 61,000 pesos. The note contains the following stipulations: without defalcation, value received, and do hereby authorize any attorney in the Philippines, in case this note be not paid at maturity, to appear in the name and confess judgment for the above sum with interest, cost of suit, and attorney's fees of 10% for collection. A release of all errors and waivers of all rights to inquisition and appeal, and to the benefit of all laws exempting property, real or personal, from levy or sale. MORB claims that the instrument is not negotiable because the stipulations are invalid. Question: is MORB correct? So, the Supreme Court ruled and said that, okay, MORB is not correct. Okay, the negotiability of the instrument is not affected by the stipulation. Okay, kung kakadiscuss ko kanina na additional provisions. Okay, although MORB is correct in stating that the stipulations are void, it is still negotiable if all other requirements of section 1 of the negotiable instruments law is present or are present. Okay, they are in the nature of stipulations authorizing confession of judgment, which is considered void for being against public policy in this jurisdiction. Okay, remember, or however, section 5 of the NIL provides that the negotiable character of an instrument otherwise negotiable is not affected. Okay, tandaan nyo yun, di ba 4 yung situations na binigay doon sa section 5. Okay, this additional provision, sabi ng Supreme Court, okay, it does not affect the negotiability of the instrument. Okay, so remember section 5. So in this case, MORB is not correct. Okay, we proceed with transfer and negotiation. Okay, if the transfer is negotiable, if the instrument is negotiable, transfer can be affected either 2 ways. Okay, It can be through negotiation or it can be through assignment. Okay? If the instrument is merely assigned lang, hindi negotiated. Kasi dalawa nga yan. Okay? Negotiation or assignment. Okay? Ulitin ko, ang transfer ng negotiable instruments, dalawa. Pwedeng negotiation or pwedeng assignment. Okay? If it is merely for assignment or the instrument is merely assigned, the transferee, okay, does not become a holder and he merely steps into the shoes of the transferor. This is the case of Salas versus CA. Okay, GR number 76788. So, any defense available against the transferor is available against the transferee. Example, okay, where the instrument that is payable to order was merely delivered without endorsement. Okay. How about issue or issuance? Okay, what is issue? Okay, as provided in section 191 of the Negotiable Instruments Law, issue is the first delivery of the instrument, complete in form, to a person who takes it as a holder. Okay, issuance to the payee is negotiation because the transfer continues the payee, the holder of the instrument. The payee may even be a holder in due course if he has acquired the note from another holder or he has not directly dealt with the maker thereof. Okay? How about delivery? What is delivery? Delivery is defined as the transfer of possession of the instrument by the maker or the drawer with the intention to transfer title to the payee and recognize him as a holder thereof. So that is the difference between a mere assignment and negotiation. Okay? So what is we're done with issuance, that is the first delivery of the instrument complete in form. Okay? And the person who takes it is considered as the holder. Okay? Tapos na rin tayo sa delivery. And next we go with negotiation. Okay? An instrument is negotiated when it is transferred from one person to another. Okay? Ano ang negotiation? Ito ang sabi ng batas. An instrument is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder thereof. Okay? If the instrument is payable to bearer, ba? Kindly read your provisions. When an instrument payable to bearer, marami yun. Okay? If the instrument is payable to bearer, it is negotiated by delivery. If it's payable to order, it is negotiated by the endorsement of the holder, completed by the delivery. So the difference between the two is, if it's a bearer instrument, it can be negotiated by mere delivery. Delivery lang kailangan. So what is delivery again? It is the transfer of possession of the instrument by the maker or the drawer. Maker, pag promissory note yung hawak niya, or drawer naman pag bill of exchange yung hawak niya. Okay, with the intention to transfer title to the payee and recognize him as the holder. Okay? So ano naman ang payable? Pag ano naman ang how is an instrument that is payable to order negotiated. Okay? If it's payable to order, it is negotiated by endorsement, okay, of the holder plus delivery. Okay? Always remember, okay, based in your section 40 of the NIL, a bearer instrument is always a bearer instrument. Okay? Where an instrument payable to bearer is endorsed specially, it may nevertheless be further negotiation by delivery. Okay? But any person who endorsing it is liable as endorser only to such holder as make title through his endorsement. Sige. Magbigay tayo ng example. Let's say, in this case given by the Supreme Court, Richard makes a promissory note payable to bearer or bearer. Always remember, a bearer instrument is always a bearer instrument, and a bearer instrument is negotiated by mere delivery. Okay? Hindi kailangan ng endorsement, delivery lang ang bearer instrument. Okay? Kung hindi nyo alam ang bearer instrument, kaya hindi read yung provisions ng batas natin, nandun. When an instrument payable to bearer. Okay? So, Richard makes a promissory note payable to bearer and delivers the same to Aurora. Okay? Aurora endorse it to X in the manner payable to X signed by Aurora Page. O, pansinin nyo, may endorsement na. Yung una is bearer siya. Yung ikalawa, di ba, tandaan nyo ang bearer negotiated by mere delivery. Okay? So, nung nakay Aurora na, okay, she endorsed it to X, okay, in this manner, payable to X signed by Aurora Page. So, nagkaroon ng endorsement. Okay? Later on, without endorsing the promissory note, X transfers and delivers it to Napoleon. So, si X ngayon, dineliver niya, okay, walang endorsement. Dineliver niya yung promissory note kay Napoleon. Richard subsequently dishonors the note. Okay? May Napoleon proceed against Richard for the note? Okay, the answer there is obviously yes. Remember, a bearer instrument is always a bearer instrument. Okay? Napoleon may proceed against Richard Clinton. Okay? The instrument was negotiated by delivery to Napoleon. Despite the special endorsement of Miss Aurora, pansin nyo doon sa binigay ko, di ba? Aurora endorsed it to X. Okay? Naging as if naging payable to order siya. Okay? Pero hindi. Okay? In your section 40, it says that a bearer instrument is always a bearer instrument. Okay? So, despite the special endorsement of Miss Aurora, it can still be negotiated by delivery because it is originally a bearer instrument. Hence, Napoleon became a holder who has a right to enforce the instrument against the maker, Richard Clinton. Okay? Yeah. I hope you understand. Okay? We go to okay. Incomplete negotiation of order instrument. Incomplete negotiation of order instrument. Diba, pansin niyo, ang payable to order na instrument is kailangan ng endorsement. Okay? So, endorsement plus delivery is equal to payable to order. Pero, ang payable to bearer is delivery lang siya. So, ang next situation natin, incomplete negotiation of order instrument. Okay? Let's say, number 1. Where the holder of an instrument payable to his order transfer it for value without endorsing it. Ko, di ba, tandaan nyo, ang payable to order, kailangan may endorsement. Okay? In this situation, the holder of an instrument payable to his order transfer it for value without endorsing it. Okay? The transfer vests in the transferee such title as the transferor had therein, and the transferee acquires in addition the right to have endorsement of the transferor. That is section 49. The second situation is for the purpose of determining whether the transferee is a holder in due course. The negotiation takes place as of the time when the endorsement is actually made. Okay, that is section 49. Let's take an example. Okay? Mr. Malakas, through fraud, okay, panloloko daw. Mr. Malakas, through fraud, was induced by Mr. Alisto to issue a negotiable promissory note payable to the order of Mr. Alisto. The payee, Mr. Alisto, delivered the note to Mr. Buwang on May 3, 2003 without endorsing it. Okay? On May 20, 2003, Mr. Alisto, upon Mr. Buwang's request, placed his endorsement at the back of the note. Pay to Buwang, signed Alisto. Question. In this situation, remember, if Mr. Buwang learned about the fraud committed by Mr. Alisto before May 2003, okay, Mr. Buwang cannot be a holder in due course, okay, because he had a knowledge of the defect of title of Mr. Alisto at the time the negotiation was made. Remember, he can be a holder in due course if he had no knowledge at the time the endorsement was made on May 2003. So, next, we go to endorsement. Ano nga bang mga endorsement? Okay? Where endorsement should be placed. Okay? Number 1, on the instrument itself. Or number 2, it can be on a separate piece of paper attached to the instrument called a longe. This is in your section 31 of the negotiable instruments law. I don't know how to pronounce this correctly, but I think it's a longe. Okay? Please correct me if I'm wrong. So, endorsement must be made of the entire instrument. Okay? Dapat, pag mag-endorse ka, hindi pwedeng chap-chapin yung instrument. Dapat buo. Okay? This is provided in your section 32. For example, an instrument for 5,000 pesos cannot be endorsed for less than 1,000 pesos. Okay? Okay? Because endorsement must be made or must be of the entire endorsement or entire instrument. There is an exemption, however, okay, when there was a previous partial payment. In your section 32 of the negotiable instruments law, it disallows negotiation to 2 or more endorses severally. Okay? For example, endorsement of 20,000 pesos, note that states pay to Jose 15,000 and Pedro 5,000. O, diba? 20,000 yung buong instrument. Okay? Ang nakalagay sa instrument, pay to Jose 15,000 and Pedro 5,000. Diba? Ang total nun is 20,000. Okay? Ang sabi sa section 32, this is not allowed. Okay? This is not considered to be a negotiation, although it may be considered as an assignment. Because ang section 32, it disallows 2 or more endorses severally. Okay? Negotiation to 2 or more endorses severally is not negotiation. It's only a mere assignment. So there are many kinds of endorsement. It can be a blank endorsement, a special endorsement, a qualified endorsement, conditional, and restrictive. Okay? Say natin. Ang blank instrument, a blank endorsement, okay? In a blank endorsement, there is no endorsee. Okay? No endorsee is specified and it is done by affixing the endorser's signature. Sa special endorsement naman, provided in your section 35, okay? It designates the endorsee. Example, pay to X. Okay? So, there is the name of the endorsee. Note that the holder may convert a blank instrument into a special endorsement by writing over the signature of the endorser in blank any contract consistent with the character of the endorsement. So, pwede daw po, okay, yung isang holder, kung sino ang may hawak ng isang blank endorsement, pwede niyang i-convert ito into special endorsement by writing over the signature of the endorser in any contract consistent with the character of the endorsement. Sinong endorser? Siyempre, yung holder of the instrument. Okay? Sinong endorser? Endorsee? Yung babayaran. Okay? Example, pay to X. Next, how about a qualified endorsement? Okay? A qualified endorsement is, okay, it constitutes the endorser a mere assigner of the title to the instrument. So, yung may hawak ng instrument or the endorser, He is merely an assignor of the title to the instrument. It may be made by adding to the endorser's signature the words without recourse or sans recourse. Mababasa nyo yung without recourse or sans recourse. Okay? Or any words of similar import. Such an endorsement does not impair the negotiable character of the instrument. So, remember, sa blank endorsement, walang specified na name ng endorsee. Sa special endorsement, merong pangalan si endorsee. Sa qualified endorsement, si endorser is merely an assignor. Okay? Or makikita nyo yung salitang, yung words na without recourse or sans recourse. Remember that a qualified endorsement is it does not impair the negotiable character of the instrument if it contains the word without recourse. Okay? How about a conditional endorsement? A conditional endorsement in your section 39, okay? In here, the party required to pay the instrument may disregard the condition and make payment to the endorsee or his transferee whether the condition has been fulfilled or not. While a restrictive endorsement in your section 36, there are three situations, okay? It prohibits further negotiation of the instrument. Example, pay to X only. There is the word only. So, it prohibits further negotiation of the instrument. Pwede ba yun? Yes po, that is restrictive endorsement. Another is it constitutes the endorsee the agent of the endorser. Pay to X for collection. So, in this one, X will receive the payment as the agent of the endorser. And lastly, if it vests the title in the endorsee in trust for to the use of some other persons. Example, pay to X in trust for Y. So, what are the rights of restrictive endorsee? Remember, ang endorsee ito yung babayaran, okay? Kasi pay to nakalagay. Kung kaninong pangalan yun ang endorsee. Okay? Section 37, it contains the rights of a restrictive endorsee. There are three. Number 1, the endorsee will have the right to receive payment of the instrument. Remember, the endorsee receives the payment. Okay? Number 2, to bring any action thereon that the endorser could bring. Okay? Number 3, it transfers his rights as such endorsee where the form of the instrument authorizes him to do so. In case of transfer, all subsequent endorsees acquire only the title of the first endorsee under the restrictive endorsement. So, we go to who is a holder. Okay? A holder in your section 191, okay? The payee or endorsee of a bill or a note, payee pag promissory note and endorsee pag bill of exchange. Okay? Who is in possession of it or the bearer thereof. That is the holder. In other words, the payee or endorsee is the holder of an order instrument. Okay? The payee or endorsee is the holder of an order instrument, while the payee or the bearer is the holder of a bearer instrument. So, who is a holder in due course? This is provided in your section 52 of the Negotiable Instruments Law. Okay? A holder in due course is a holder who has taken the instrument under the following conditions. There are 4. Ang shortcut key natin dito is COGI. COGI. Okay? Number 1, letter C, or that it is complete and regular upon its face. Letter O. Okay? Overdue. Okay? He became the holder of it. Excuse me. He became the holder of it before it was overdue and without notice that it has been previously dishonored, if such was a fact. Letter G, that he took it in good faith and for value. And letter I, that the time it was negotiated to him, he had no notice of any infirmity in the instrument or defect in the title of the person negotiating it. Okay? Remember this one. The general rule is that all holders may sue and avail such defenses, okay, except those, okay, not a holder in due course. So lahat ng holders, they can sue and avail all defenses if they are a holder in due course. However, they cannot avail some defenses if they are not holder in due course. Okay, let's say in this even a holder not in due course, okay, remember that he can sue in his own name and payment to him in due course discharges the instrument. This is section 51. The only disadvantage of a holder not in due course is that the instrument is subject to defenses as if it was not negotiable. This is the case of Dino versus Hodal Loot. Can a payee be a holder in due course? Yes. Okay. Section 191 defines a holder as the payee or endorsee of a bill or note who is in possession of it or the bearer thereof. Hence, the holder in the first clause of section 52 and in the second subsection thereof may be replaced by the definition in section 191 so as to read a holder in due course is a payee or an endorser in possession. Sige, gumawa tayo ng case mamaya. How about an accommodation party as provided in your section 29? Okay? As regards an accommodation party, okay, the fourth condition, which is the lack of notice of any infirmity in the instrument or defect in the title of the person negotiating it, has no application. Okay? This is the case of Stelco versus Court of Appeals. Okay? Sabi ng Supreme Court, however, the inapplicability of the fourth requisite is limited to the notice of absence of consideration o yung bayad. That is, notice of the fact that the party is a mere accommodation party who did not receive any consideration of the instrument. Bakit? Kasi nga, hiniram lang yung pangalan niya. An accommodation party lets you borrow his name. Okay? If the holder has notice of the infirmity in the instrument or defect in the title of the person negotiating the instrument, then the holder is subject to personal defenses. So let's go with some examples. Ara is indebted to Ben in the amount of 100,000 pesos. In order to raise funds to pay for her obligation, Ara sold her old car to Chito for 100,000 pesos on January 20, 2021. Okay? Ara agreed to deliver the car to Chito on January 25, 2021. 5 days nung hiniram niya 5 days from the time that she sold the car. Okay? However, Ara convinced Chito to immediately issue a check and to make the check payable to Ben. Si Ara daw na-convince na si Chito na mag-issue agad ng cheque para mabayaran si Ben. Okay? So Ara informed Chito that the check will be issued to Ben because of Ara's outstanding obligation. So si Chito issued a check to Ben to pay for the loan of Ara payable on January 25, 2021. The check was delivered to Ben through Ara. Ben and Chito were not aware that at the time the car was sold, it was already destroyed by fire. So, Ara fraudulently hid such fact in order to convince Chito to issue the check and to convince Ben to accept the check. Can Ben, the payer of the check, be considered a holder in due course? So, the answer there is, okay, Can Ben, the pay of the check, be considered a holder in due course? Syempre naman. Okay? Ben is considered to be a holder in due course. Nothing in the problem indicates that Ben is not a holder in due course. Hence, the presumption that he is a holder in due course. Remember na ang presumption or the general rule is all every party in an instrument is a holder in due course. Okay? All the requirements of Section 52 of the Negotiable Instruments Law, yung COGI, are present in the case because it appears that Ben is a holder of the instrument who has taken the instrument complete and regular on its face. He took it before it was overdue and it was not previously dishonored. That he took also the instrument in good faith and for value. He had no notice of any infirmity in the instrument or a defect of the title prior of a prior party. So that's it. Another situation. Pogi issued in favor of Jojo a post-dated cross-check in payment of newsprint which Jojo promised to deliver. Jojo sold and negotiated the check to Excel Corporation at a discount. Excel did not ask Jojo the purpose of crossing the check. Since Jojo failed to deliver the newsprint, Pogi ordered the Drawy Bank to stop payment on the check. Efforts of Excel to collect from Pogi failed. Excel wants to know from you as a counsel. Is Excel a holder in due course? The answer there is no. Excel is not a holder in due course. Okay? The instrument involved is a cross-check and it was supposedly to be for deposit only. Remember, ang check na cross-check, makikita nyo there are two parallel lines sa check. Okay? That is for deposit only. Remember, deposit only ang cross-check. And always remember that if the check is a cross-check, inquiry must be made. Okay? Magtanong ka dapat. So, in this case, Excel is obligated to inquire regarding the circumstances involving the issuance of the check. Failure on the part of Excel Corporation will prevent it from becoming a holder in due course. Such failure or refusal constitutes bad faith. Second question. Can Pogi raise absence or failure of consideration as defense? The answer there is yes, syempre. Since Excel Corporation is not a holder in due course, Excel is subject to personal defense which Pogi can set up against Jojo. There was a failure of consideration in the problem because Jojo failed to deliver the newsprint to Pogi. So, last topic for this part 3, rights of a holder in due course. Okay, in your section 57 you can find there the rights of a holder in due course. That is, a holder in due course holds the instrument. So, a holder in due course is one who holds the instrument free from any defect of title or of prior parties and free from defenses available to prior parties among themselves, and may enforce payment of the instrument for the full payment or full amount against all parties liable thereon. So, number 1, remember, a holder in due course is free from personal defenses. Okay? So, a holder in due course is also, okay, a holder in due course is not free from real defenses. So, free lang siya sa personal defenses but not on real defenses. We will discuss that later. Ano ba yung mga real tsaka personal defenses? It will be discussed on our part 4. Okay? Also, a holder not in due course is subject to personal and real defenses. So, the difference between a holder in due course and a holder not in due course is, yung holder in due course, sa real defenses lang siya hindi free. So, in a holder not in due course, hindi na nga siya free sa real, hindi pa siya free sa personal defenses. So, may one who fails to inquire as to infirmity in a negotiable instrument and defect in the holder's title be a holder in due course? The answer there is yes, in the case of De Ocampo versus Gatchalian. Yes, because the law does not impose on a holder the obligation to inquire into the infirmity in the instrument or defect of the title of the person negotiating it. However, okay, failure to make inquiry when the circumstances indicate defect, it renders the holder not a holder in due course. Gross negligence may amount to legal absence of good faith. Parang yung kanina yung cross-check. So, that ends our discussion for part 3. Thank you for listening. You can also read the book of Hector de Leon, the book of Sunjang, and the book of, I think this is Villanueva. Yeah. Miravite. So, thank you for listening and have a great day.